For oral arguments in cause number CR 150302, State of Arizona versus Jodi Arias. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 30 minutes for their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs, we have conferenced this case, we are familiar with the facts and the evidence presented at trial. Please take that into account when formulating your presentation. At this point, counsel, are you ready?
Yes, ma'am.
Please proceed.
Good morning. May it please the court? My name is Corey Engel, and along with co-counsel Peg Green, I represent the appellant in this case, Jodi Arias. This court should reverse Ms. Arias' conviction because it was obtained during an unfair trial. The prosecutor in this case engaged in pronounced and persistent misconduct which permeated all stages of the trial. His misconduct began as early as jury selection and continued as late as his closing arguments.
If you had to identify the top 3 acts that you believe most impacted the trial, because in your brief you've alleged multiple, what would your top 3 be?
The very worst act of misconduct that Mr. Martinez committed was, and this sounds as if I'm avoiding the court's question, but it was the cumulative misconduct. Because that misconduct worked together to build on itself across the entire trial. He had a theme that he was working from and a goal he was working towards, and he used his misconduct with each one of the witnesses to keep working towards that goal in his closing argument, and then he capitalized on it at that point. So it truly is the cumulative error in this case, the synergistic effects between the different kinds of misconduct that was committed that is the worst misconduct here.
Define what you refer to as the theme. You said he had a theme to work on. I want to hear what your definition of the theme is.
The theme in this case was nobody in this trial is telling you the truth or should be trusted except for me. I am the only person here who is above board, who is ethical. He made every one of the defense experts out to be a person who had a relationship with Arias and who had been hiding evidence and who had changed evidence based on their feelings for Arias. He alleged that the defense was fabricating their case, and in his closing argument, he hit on that theme again. And he even went so far as to argue that everything that came from one of the witnesses was nothing but contaminated filth. So the theme in this case was, everybody else you should ignore except for me, and not because of the evidence, but because of the prejudice and sympathy that he had attempted to invoke in the jury against those witnesses.
There were suggestions, there were assertions, I believe, that experts had emotional attachment to the defendant. Is that correct?
That was certainly Mr. Martinez's accusation.
Give me your best assessment of the premise for that.
Mr. Martinez's premise for that?
The assertion is you have feelings for her. Wasn't that the assertion? Give me the state's basis for that.
Well, the state's basis for that was a misleading cross-examination in which he used the fact that an expert who routinely, like a psychiatrist or a psychologist who routinely meets with people who are in jail and sends them books, that simple act that he commits with every person that he meets with was enough to assume an actual relationship and feelings for this particular defendant.
We're talking about Dr. Stewart specifically, correct?
Dr. Samuels? I'm sorry.
Samuels, sorry, wrong
Yes.
S name. Okay, so Dr. Samuels specifically, and when we look at the cross-examination of Dr. Samuels, the prosecutor does go into a lot of depth about that being the giving of a gift. Other than that single giving of the book, was there anything else evidentiary-wise to support his proposition that Dr. Samuels had developed feelings for Miss Arias?
Other than his own assertions, no. That was it. He did attempt to get Dr. Samuels to define the definition of compassion and whether he felt sorry for Miss Arias. And the doctor repeatedly said, no, I don't feel sorry for Miss Arias. And then later on in another portion of the case, he asked a misleading question of the doctor where he said, well, didn't you earlier during your testimony use the word sorry? And while the doctor did use the word sorry, it was only in reference to saying, that's not how I feel about Ms. Arias. But the way that Mr. Martinez was able to frame that question made it a very misleading cross-examination. It made it seem as if the doctor was trying to hide something he'd said earlier.
Okay, so we're going back to your top three. We've got cumulative misconduct. The theme of the case, everyone is a liar here but me. What would be your number third?
It would be the accusations of the experts having relationships with Arias, and the accusation that they were hiding evidence, the accusation that they had changed information on the testing forms, and the way he tied those together across both experts, to the point that the jury was even asking questions about whether or not the second expert had feelings for Arias, and asking the second expert if it was possible that the defense was hiding evidence from her in order to get a better opinion from her. So that's the way in which you can see that he built on his misconduct from one witness to the next witness to his closing argument. They wove together to tell one story. So that would be my second or third, however you want to count that, worst examples.
If that's your second, do you have a third?
I think that the persistence and improper questioning by itself is enough to warrant reversal on its own, as the Poole court found in that case, based solely on improper questioning. They said that reversal was warranted. And I believe the kind of improper questioning we have here, the amount, the type, the persistence in it, is much greater even than was found in Poole.
So let's assume we agree with you on all the points you made thus far. How precisely was the defendant denied a fair trial?
Arizona sets forth the test for what a fair trial is when cumulative error renders a trial unfair, and when prosecutorial misconduct mandates a reversal, as when that misconduct is so persistent and pervasive that it permeates a trial. And that's State versus Hughes. Hughes is adopting or setting forth that test based on the United States Supreme Court case of Donnelly, which talks about when due process has been violated, when a trial has been so infected with misconduct that it violates the due process clause. So that's one of the basis from which the Hughes decision comes. The second is that it's adopting the language from Berger, which is also a U.S. Supreme Court case, on pronounced and persistent misconduct that permeates the entire trial. That's the test, that's the four corners of when do we have to reverse for prosecutorial misconduct.
Suggesting that prejudice is presumed here under the third prong of Escalante?
Yes, I am.
I mean, aren't you also saying in that same, by drawing that conclusion, aren't you saying that there's structural error?
Yes.
But okay, let's talk about it. Share with me some of the examples that the Arizona courts or even the United States Supreme Court have found to be structural error.
I don't have specific cases where I can tell you this is what the court found.
Like complete denial of right to counsel.
Right. I know that the definition of structural error involves the kind of error which makes the actual ability to determine guilt and innocence. It affects the overall mechanism by which we determine guilt or innocence and makes that unreliable. And it's the very unreliability of the trial because of the amount of the misconduct that makes this the kind of case where you do presume prejudice. And that's because if you consider the kind of error that we're talking about in Escalante, that third kind of error, where the error is so egregious that a defendant could not possibly have received a fair trial, that language of that test matches the language that Hughes adopts from Donnelly and Berger, or error which so infects the trial with unfairness that it violates due process.
do we ignore the Arizona case law that talks about balancing the overwhelming evidence of guilt against the prosecutorial misconduct? I mean, we have a whole line of case law that says if there's overwhelming evidence of guilt, we are not to overturn a conviction based on the conduct of the state.
No, you absolutely should not ignore those cases, but it's very important to differentiate between a case where we're reviewing for individual error, which is reversible on its own, and for which the standard is first you prove that there is error, and second you prove that that's prejudicial. And whether or not it's prejudicial is dependent on whether or not the defense objected, so to use harmless error or fundamental error at that point. Because we're not specifically at this point arguing under the individual error standard, we're asking the court to make a finding under the cumulative error test. The cases which deal with overwhelming evidence of guilt are the ones that are addressing whether or not prejudice has been proven after error occurred. But because the cumulative error test, when proven, includes both the error and the prejudice as escalante, that sort of an error proves both error and prejudice, and a defendant is not required under that third prong to separately prove prejudice after they've proven that their trial was rendered unfair. It's not that we're asking the court to ignore that line of cases. We're asking the court to proceed under a different avenue of cases, a different branch of consideration. And the avenue that we're under, we would not separately prove error from prejudice. Once you've met the cumulative error test, there isn't an additional review for fundamental or harmless error.
Are you aware of any case, either Arizona or otherwise, that has held, notwithstanding the overwhelming evidence in this case, we conclude, or we hereby reverse the conviction based on pervasive misconduct, cumulative misconduct, intentional misconduct?
Yeah, Arizona cases on prosecutorial misconduct where they've actually reversed, it's a very small body of law. There are about 4 cases.
Use pool and maybe a couple others.
Minutes and the recent case from Division 2 in Dansdale. As far as I could determine, Hughes is the only case where there is an affirmative finding of cumulative error in Arizona. And what we learned from Hughes and looking at what the Hughes court did is that after they found cumulative error, they did not apply harmless error or fundamental error review after they found cumulative error. Now, they did talk about harmless error, and there were 4 sections of the opinion where they started analysis of whether or not the defendant objected to this kind of error and whether or not there was overwhelming evidence of guilt on those particular categories. But then the court moved away from those categories, found that cumulative error existed, and then the very last sentence was, we don't need to decide which ones of the individual errors are reversible on their own, because we find that cumulative error exists here. And so we're essentially asking the court to engage in the same sort of analysis. Rather than doing the individual analysis first, then moving on to cumulative error, we're asking the court to find the cumulative error first because it's so persistent and pervasive in this case. Just as a matter of judicial efficiency, it's easier to come from that direction than to work the other way through each example.
I'd like you to move on a bit to the publicity aspect of this case. And I'd like you to address the court's role in making sure that publicity is appropriate for a courtroom setting. And also, what steps should the court take in ensuring that publicity doesn't create that carnival-like atmosphere that we talk about?
The defense requested that the court sequester this jury. That would have been the best way to minimize the worst effect of the carnival-like atmosphere. It may still have continued, and you still would have seen the effect that this atmosphere had on, for instance, the witnesses who were being harassed and threatened, or the defense attorneys who were receiving death threats and were being followed from court to dinner at night and having their photos taken. The court doesn't have the ability to control what the public does, but they have the ability to control the things that are feeding the lynch mob mentality that was happening with the public. They can control whether or not the jury is impacted by that by sequestering the jury if it's necessary.
When we talk about the impact on the jury, Judge Stevens was quite careful to questioned them often about their exposure to the media, etc. And they all assured the judge that they could remain fair and impartial. When we look at what defense counsel did, Judge Stegeman asked, do you want the cameras out of the courtroom? Defense counsel said no. There is one instance in over 60 days of the guilt phase of this where defense counsel said, yes, we'd like the cameras out of the courtroom. And the judge said, can you put that request in writing, which defense counsel did not do. So given that, how do we address the challenges you've brought up regarding the carnival-like atmosphere of this case that you've alleged in your briefing?
Well, separately and apart from asking for relief purely based on the publicity portion of the case, we're asking also that the court consider the way in which the prosecutor's behavior fed into and capitalized on that publicity.
If we consider the prosecutor's behavior in churning this publicity, don't we also have to look at Ms. Arias's engagement with the media? Because in my review of the record, it appears that she began courting the media.
After Ms. Arias was appointed counsel, I believe there was one interview that she gave, and that interview was on the day that she found out she was eligible for the death penalty. So, and she certainly wasn't standing on the courthouse steps signing autographs with fans or taking photos with fans.
No, she was giving an individual interview in a private interview session with members of the media.
And it's not to say that there isn't some consideration of that. Obviously there should be.
Counsel, you say some consideration. Didn't the defense approach the judge at one point and say that they were struggling because it appeared Ms. Arias was attempting to try her case in the media?
You know, I don't remember that specific statement, but I take the court at your word that that's what. I just don't have a memory of that. But assuming that was true,
was it pervasive at the start with Ms. Arias? Getting out in front of the media as much as she could?
There were 3 interviews given, 2 of which were before she had counsel, and 1 of which was afterwards, and was the day that she found out she was eligible for the death penalty. So to say that Ms. Arias was the one that was courting the media, I don't know that I don't believe that the record supports that. I believe that.
For a moment, though.
Yes.
Ms. Arias also voluntarily gave an interview after a verdict was returned, did she not?
Yes, that was the day that they found out that the.
Okay,
yes,
so we're talking about, and I just want to clarify that happened at the end. So we have 2 before and 1 at the end.
Yes.
So it doesn't appear that she ever gave up on her desire to get her story out.
I would disagree with the court respectfully on that, because given the amount of media attention and the amount of the fact that there were no interviews during the trial shows that there was some control over whether or not Ms. Arias was courting the media. If Ms. Arias really wanted to be in the media, she could have been doing interviews nonstop. But what we had was a definite lull as soon as she had counsel, which there's nothing in the record to support this, but as a defense attorney, my understanding would be that the very first thing you do is explain to your client.
How, as an appellate court, are we supposed to parse out which party's actions contributed to the interest in this case, leading to what you allege was a carnival-like atmosphere?
Well, there's only one party when we're talking about the difference between Ms. Arias and Mr. Martinez that has an ethical duty not to try his case in the media. And that's not Ms. Arias. That's Mr. Martinez.
Agreed. But we'll put the ethical issues aside and we'll discuss those in the context of prosecutorial misconduct. Let's talk about when you make a challenge about publicity.
Right.
How do we determine from a cold record who was at fault for churning the publicity bandwagon, so to speak?
I'm not sure that the court, there's any mathematical formula that the court could use or apply to say, well, because Mr. Martinez did this many acts in front of the public and Ms. Arias did this many acts in front of the public, we can therefore say it's a balance. What the court has to look at is who had the greater ethical duty, who benefited from the media attention. because
Counsel, isn't it kind of ludicrous to sit down and say that we can look at the conduct of Ms. Arias and we can look at the conduct of Mr. Martinez and apply no standard, but just simply assume that the one did greater damage than the other when she's out there telling the story as widely as he's doing what he's doing in the courtroom?
Again, I would disagree that Ms. Arias was as widely as Mr. Martinez spreading her story. I disagree that she was doing so during the trial. She did not. Mr. Martinez did. Ms. Arias did not tell the court when the court questioned about the unfairness of signing autographs on the courthouse steps, as Mr. Martinez did. His response was, it wouldn't matter even if the jury did see it, and it's not misconduct if I do it outside the courtroom. Ms. Arias at least responded to, I'm assuming based on when the interview stopped, responded to her advice of counsel to stop doing interviews. And I wanted to go back to a point that the court made earlier about whether or not we can trust that the jurors didn't, when the court was asking the jurors whether or not they had actually been affected by the media in this case. And given that they said numerous times that they hadn't, whether we should trust that. First of all, we know that there is case law that indicates that at some point you don't necessarily keep assuming that the jurors are being accurate, that they have had no impact by the media in the case. And you especially shouldn't on this record when you have at least one juror who, when the court was considering whether or not they would strike her the next day, she went home. She came back in tears the next day because when she got home, her husband had let her know that based on the news coverage, she might be struck. Then the court asked her, but you're not supposed to be watching the news. Oh, I'm not watching the news. Nobody's telling me about the news. So we don't always get a precisely accurate response from jurors who know that if they say that they are watching the news or they have been impacted, that they're going to be struck from a jury that they've been sitting on for quite a long time and don't want to be struck from. And that's one specific example that we actually have in the record, not an assumption that I would ask the court to make, but an actual fact in the record to support the fact that the jurors were not accurately reporting whether they were affected.
That juror had additional issues that were not disclosed during voir dire, and when we look at what the substance of her testimony was, it was questionable to begin with. So striking her was the appropriate course of action for the court, agreed?
Absolutely.
And did that not cure the issue?
Yes, and I wasn't bringing up that particular juror to argue that there's some sort of reversible error with regard to that, but only in that is an example of the way in which jurors believe that they are truthfully and accurately portraying to the court that they've not been impacted by the news or the media or anything that's happening outside the courtroom, but when in fact they are, and that they're answering the question so that they can stay on the jury.
If we were to accept that premise, would it not undermine our entire jury system?
If you did it in an average case where a jury wasn't asked as many times as this jury was, whether or not they could still be fair and impartial. If you did it in a case where this jury was actually escorted back and forth from the courtroom by SWAT members. So the idea that this is an extreme case, this would be a rare finding from a court, not necessarily one that would apply to every single case of which the court was bringing up just now.
When we look at our tradition
Yes.
of relying on citizens of this country to sit in judgment of other citizens, and we rely on them to tell the truth when questioned, if we were to say, we don't trust you here, doesn't that mean we can't trust them at all?
Case law has come to that conclusion that at a certain point when jurors have been asked this many times, or whatever the standard is in the case, and I believe it was Irwin versus Dowd, that there comes a point at which you stop assuming that the jurors aren't affected by the media and are not affected by the media and the circus-like atmosphere, even though they're reporting. And I'm not saying that the jurors are lying. I'm saying that they're doing their best to report, but their report isn't necessarily accurate. The juror that I'm talking about, when the court said, but how did your husband even know which case you were on, was flummoxed. It was very clear that the juror didn't believe that she violated the court's orders in any way, and the court didn't make a finding of that, but she definitely was receiving information.
And she was removed from those that sat in judgment of Ms. Arias.
Right.
So Is that not the remedy that should have occurred?
It is the remedy that should have occurred, but when the court is weighing whether or not the jury was affected by the media, the sole basis of the court determining that can't be that the jurors told us that they were not affected. Because if the media and the circus-like atmosphere is bad enough and continues for often enough, and the jurors are impacted in large ways and small ways, large ways like being escorted by SWAT team members, small ways by being asked 15 times, can you still be fair? Have you seen anything? Are you watching the news? Did you see anything outside the courtroom?
So is 14 times too much? Is 13 times too much? Is 5 times too much? I mean, you're asking us to enter an order that would affect the propriety of the tradition of our country of using jurors to determine guilt or innocence. That's a slippery slope. Would you agree?
I agree that it could be, but it's always based on the facts of a particular case. And when courts make a ruling, it's always tied to this case's facts. In this case, the facts are fairly extraordinary. I don't believe that the court is going to be setting a precedent that is going to apply to every jury in Maricopa County. We don't have this kind of media coverage or this sort of a media circus in every single case. And hopefully, in the next case, the court will impose some restraints earlier on in the process.
Let's talk about that.
Okay.
Okay. So, publicity was an issue. I want to know what you think the court failed to do in reining in, one, the media or the publicity, and in this developing technological age where we're tweeting, we're Snapchatting, we're doing all of this stuff. So it's not even the traditional media, it's anyone has access to this information. What could the court do, and what did it fail to do? And also, what did the court do, and what did the court fail to do in regard to prosecutorial misconduct? And you have 4 minutes, so I just want to get that out there.
Okay. With regard to Mr. Martinez and what the court failed to do, the court failed to enforce its own orders, its own rulings against Mr. Martinez.
Was it too tolerant? Simply too tolerant?
Yes. I mean, the case law indicates the courts cannot be merely a passive observer in the trial process. And the best way to stop guerrilla warfare in a courtroom is for a strong judge to issue rulings and enforce them.
So she can't just tell him 100 times to back off.
Right. And she also can't sustain an objection to something he's said, have him come back and ask the exact same question, and then overrule the objection that she gets from the defense saying, Your Honor, he's doing it again, which is what happened here. So the court needs to also, when a prosecutor is being this persistently pervasive in their misconduct, needs to admonish the prosecutor that they're in danger of causing a mistrial, which the court actually did here at one point regarding speaking objections, but Mr. Martinez then engaged in 26 more speaking objections afterwards. So at some point, the court has to be willing to and has to let the prosecutor know that they are willing to declare a mistrial if the prosecutor is endangering the right to a fair trial, and that's simply not what happened here. I'd like to reserve the rest of my time, if I may.
Thank you, counsel. Good morning.
Good morning, Your Honors. Terry Chris for the state of Arizona. State v. Johnson of our Arizona Supreme Court says, to prevail in a claim of prosecutorial misconduct, a defendant must demonstrate that the prosecutor's misconduct so infected the trial with unfairness as to violate due process.
Chris, before we get started, I'm looking at page 99 of your brief. Let's get started there. The state